There we're rolling.
All right, before we get in, we got any questions? Okay. What we're going to do this time, I'm going to show you. I'll show you. Basically, how this plays out in your contractual affairs. Okay, first thing with every contract is, every time they give you an offer, what do you do?
Accept it with honor.
Accept for honor. There's no such thing as accepted for value. You accept it for honor, which means if it defaults, you agree to pay for it, but what you do on the ass end of this, trade to the other treasury with a $1 stamp underneath it that you sign over without recourse. This is the basic of your contract.
Can you fix me a thumbprint to it?
You don't have to.
Okay.
This is the basics of your contract right here. I don't care what the offer is. You accept it for honor. You make it payable to the United States Treasury because here, accepting any interest. Any property on this earth, you have any interest in it. It's undefined, it's unknown, it's undisclosed, it's unvalued, it's uncalculated, it's unmeasured, and it's unweighed. It's in any interest, like this eraser. I have any interest in this eraser. Doesn't matter what it is, it's in any interest. You take this any interest and you assign it. This creates, when you do this creates an assignment. And the assignment is what seals the contract. You've accepted the interests. You've now assigned them to the United States. Now you have your contract under international law.
It's your consideration.
Because you're in fulfillment of the one they gave you under the birth certificate and the Social Security. Social Security, remember, is Hague Article 43, Restoration of Public Order and Safety. When they registered the birth, they registered an account that they expected to receive something from. An equity. This is your equity. Your signature, your energy, your equity. That's what you're giving them. An equitable contribution of debt so they can retire it and never reissue it. And it's all done 31 USC 3113.
C, isn't it?
What is that now? 31?
31 USC 3113. There's 3 ways you can do the gift. Give them a gift of debt that they retired, never reissued. Give them revenues they can use against the public debt, and then you turn around and take anything in excess and tell them to reinvest it into the infrastructure of the 2009 American Recovery Act. Thank you, Obama. The third one is where any property assigned to them as a result of this is then sold to reduce the debt. So each way you're doing this, you're making them reduce the debt, and the one you give it to is the Treasury, but you nominate the judge or the CFO or the CEO or whoever's making the claim as the executor over this one moment. A special executor of this account for the purpose of collecting instruments, proceeds, and accounts for delivery to the beneficiary, the United States. You are now the trust protector of this instrument, of this trust. You just created a trust by the assignment. Now it's your job to make sure it gets there.
So they're assuming the position as an executor based on tort for one transaction or one transaction only?
No, you're assuming special executor for that. They assume the executor based on tort when they refuse to do it.
Correct. That's when the
Now, when they refuse to do this, you flip it over on them. Okay, they decided they were going to go into the reverse of this, and they're going to bind themselves to it. The reverse of this is one word. You have a one-word contract and a one-word trust. You don't need to define it. You don't need any documentation to go with it. This is already defined. In actuality, you have a contract under tort, under a tort, because of the violation of the contract you just gave them. Now they're going to enter into a trust which is a split equity. Because usufruct is actually a naked owner. So the contract spawns the trust.
5% naked owner in this application, right?
No. Remember, the grantor of the trust is the one who violated the contract.
Correct.
He now owns 100% of the value.
Oh, good, so it's all the liabilities on
Because
good.
the whole rule of usufruct, and our whole rule of reversion, is if a grantor of a trust owns over 5% of the value of the trust in reversion, he is treated as owner for the whole of the estate and is taxed accordingly. When these guys do their dishonors and they refuse to do your contracts, are now in a contract under a tort for violation of the contract outside the scope and authority of their office, because their only job is administration of this public estate, of this public trust. And that's it. They have no other authority. They're here to administrate that public trust under their international organization through international rules and policies designed to administrate the public trust that is the United States of America, because it was created within the sphere of the law of nations, not the United States. The public trust was created in the sphere of the law of nations to give everybody a safe haven, a safe harbor. And it's been extended around the world now. Everybody can get into this. All you have to do is accept the parameter, the principal philosophies found within the Declaration, which is the last line. You pledge your life in service of making everybody's life better and the world better. You pledge your fortune in that anything you would have garnered in that goes to that purpose. And your sacred honor in that you defend and honor your obligations and contracts. And that's how you flip this around. Because as soon as they go into it, usufruct is just an exercise of right. They don't even have to have the right. They just have to exercise their right to it. Even if it didn't exist, it does now. Because this is now the future. This is your security. Because the duties of the usufruct were to what? They were to put up a security, they were to pay taxes, settle all claims, keep an inventory, make repairs. Any failure on any one of those is a breach of the contract and the trust. So now you have a violation, now you have a tort, which results in a usufructory contract, which results if they breach it into liquidation. And when you go to liquidation of a usufruct, it's not only the security they gave, it's any profit they would have received from the use of it. Not only money. It could be houses, cars, boats, buildings, everything. Doesn't matter, because whoever violates the contract is now the usufructor. And what is the rule of thumb of the usufruct? Whoever holds the usufruct is a fuck.
That's easy to remember.
That's the whole remembrance. That's how we remembered it. Because of the duties associated with it. This guy right here, the naked owner, always has disposal.
Right of direction.
Yep. He has the right to direct however it's going to be used. This guy gets everything left. In other words, if I was to eat an apple, he gets whatever I shit out.
Nitrohumus.
That's the basic.
Fertilizer.
Now, in Roman times, the slaves owned the usufruct. They had all the money, all the tools, all the skills, everything else. The politicians were the naked owner. Who do you think directed Rome? The naked owner. And when Caesar came along, he just said, accept me as Christ in public, and whatever you do in private, I don't give a shit. That's all he said. That's the whole Bible is all written on Julius Caesar, by the way.
So that's why they call them public servants, huh?
Yes, they're public servants because they're serving the public trust. And when they come in through their international organizations, they are also administrating those trusts. They're administrating the public estates called people and their interest, because what is an estate? In its basic form, an estate is just interest in property. It's not the property itself, it's your interest in it. The property will always remain with the public trust, but your interests are like movable land. They go with you. When these guys administrate it, they must put up a security to show they had the right to your interest. If they don't do it, it's an automatic breach, because every court case is an act of war. Every court case comes in under law of nations because they're trying to collect on a debt in violation of the law of nations. And what happens is they interfere in the contract. Now it becomes 15 USC 1. They impeded it in violation of their duties to administrate the estate. And now what you, can you put up that other PDF? Or that the Word document.
Sedition.
Go back. Okay. You going now? Go back up. Sorry. Keep going. No, go back down the page. Keep going. Keep going. Keep going. Keep going. All right. If any get in your way, it is a violation of 15 U.S.C. 1 for impediment of a contract, Article 46 for interference with the proper administration of government by an international organization. They no longer have the immunities and protections and all the other crap they keep calling about. They are now terrorists. And under the law of nations, every nation on earth has an obligation to hunt them down. Alright, why? Because they're interfering with the proper administration of government to interfere with you reclaiming your estates. You're called infant. That name is an infant. When they call you name and number, they're calling you an infant, which means that's your damn estate. You claim it. You operate it. Once they get in the way of it, now it's violation of 1666 Kesteste Vi, and now they are in trouble. Because the international law will not protect them, and United States law can't protect them. It is an impossibility of that law, because it interferes with the proper administration of government. When the infant comes back, everything's supposed to revert back to them immediately. Not with delay, not by going to court, not for asking for it. It's supposed to happen. Now here's the problem, what we're having is they're not really accessing your estates. They're putting liens against them and selling the liens on the markets. So when your estates revert back to you, all that other crap reverts back to you too. So that's why you get rid of the reversionary interest, so it doesn't go to you, it goes right back to the United States, and they've already got the benefit from it. Now they have the liability to sell it.
Also, too, if they impede that contract with the proper administration, it's bankruptcy obstruction because the United States has been bankrupt.
No, actually, when they impede the contract, they become bankrupt.
Correct.
They become bankrupt, and now if they continue to do it, now it's impeding the bankruptcy.
Correct. It's bankruptcy obstruction.
Correct.
Under the law of the Geneva Convention of 1930, which has been recodified in 1933 under HJR 193.
Right. Well, there's when you come in under the contract, but I don't even bother with that because I don't care.
Yeah.
The second they violate the contract, they're bankrupt because they have no value, no moral, no code, no ethics, no nothing. They're in dishonor. Dishonor is bankruptcy. Whenever you go into dishonor a contract, what do? They liquidate the damn contract. And that's what they're doing in these courtrooms. They're liquidating contracts. The only thing is, you're the infant because they called you by that name, so stop letting them interfere with it. Claim what is yours and hold them to it under international law. They can't hold back against that. That's the one thing they cannot violate. Because that destroys the whole premise of them even being here. Now they're just barbarians at the gates. They're just terrorists. They're terrorizing you into an economic servitude of something that the United States has already purchased.
That's why we're all here. They're terrorists.
Yeah. So now it's a matter of 14th Amendment public debt obligation for indemnification of reciprocation for what they purchased. They're getting in the way of this, and we're letting them. This is their duty under international law. They chose this. 13th Amendment's involuntary servitude can't exist. They came in here and volunteered to do this by showing up. This is their duty they volunteered to. The public debt cannot be questioned. And now, when you come in under Article 1, Section 8 to fulfill it, now the U.S. has a duty to come in under here, and all the insurrection and rebellion costs will be borne by the U.S. They'll go after the one who caused the insurrection or rebellion. And that's basically how they trick you in the courts. Is you go in there, they have a contract already ready to go, they trick you into pleading to it or whatever else to it, you do something on it, suddenly now you're the one in insurrection and rebellion, because you just didn't do your duty and sign it over to the state. You tried to fight it. You tried to fight the one coming after you, took it on by yourself. Social Security birth certificate means they subjugated that claim. You don't have the right to do that anymore. Now you're the one in tort of the contract. You're the one who violated it. You're the one who's the tortfeasor. You're the belligerent. You're the hostile. You're the insurrection and rebellion. Now your property becomes forfeit under the rules of war, and all these local courts, they're just pride courts. They're just divvying up the booty, and your ass is it. Because you didn't choose this.
Is it never too late to do that?
Oh, no, it's never too late.
Okay.
It's never ever too late to do this, because why? You can always repent. Repent just means what? Change your way of thinking.
The
That's
trust,
all it means.
the trust is separate from the debtor, so he can always come in.
Correct. The estate and the estate and the debtor are two different entities. That's 11 U.S.C. 558. Their bankruptcy code. The trust and the debtor, or the debtor and the estate are always two separate entities. And if the debtor waives his defenses or anything else, the estate does not. He can always bring it up at a later date. So you got your name, which is just is the debtor, and this, the lowercase name would be the estate of the debtor. So you have the one who owes the debt and the estate of the debtor. Two separate entities. They're not the same.
So if they violate that, now where do you go from?
That you would go with the Attorney General. They can't have the ability to maintain, because remember, this is where you're coming in. These guys are the ones with the duties. So you take it to the Attorney General, the Secretary of State, and let them know there's been a violation of the law of nations. And if there's a violation of the law of nations, they must do something about it. If they don't do anything about it, was it the Queen's Bench was in Philadelphia?
Yeah.
Who told me that?
King's Bench is in
King's Bench, Philadelphia. You take it to them. I go, look, dude, your dude over here is being an asshole. Here's the evidence. I want you to take care of it. They don't do anything about it, you go in international court.
What's the
You
penalty for
also have an option to go into Delaware in a chancery court.
Yeah.
But, because every state is under a franchise to Delaware.
Okay.
And because the state bar associations are holding a corp sole under Delaware.
Right.
So where is the international court?
That would be, there's one in New York, I know. I think that's the trade. And then you got the one in Brussels, or Netherlands, or something like that. And let them go after them.
The Hague.
The Hague. That's what those guys are there for. And how you do this, once they violate the law, they don't have the protections, Nuremberg applies. The Nuremberg principles. They cannot hide behind these corporate shields. They cannot hide behind, oh, the law doesn't exist. No. Nuremberg specifically states, just because the law is not codified in a nation doesn't mean it does not there. That means it is. It's there for everyone to use. These guys cannot hide and do this to the people all the time. They're doing it not just to America, they're doing it all over the world. All right? This is not just our problem. This is the world's problem.
And the one thing, when they issue a citation, it's not in the folder, which that citation determines the contract. And they sell that transfer.
Okay, the citation itself is a lien. It's just, that's all it really is. The contract is your acceptance of it, and then the assignment to the United States. That's your contract. What they're doing is they're putting a lien against the account and selling that off. So that's all they're really doing. So you're coming in under your duties to acquire property and interest. Doesn't matter what the interest is, just an interest. Any interest. You're acquiring any interest for delivery to the United States. Thus, under under 12 U.S.C. 95A, the Trading with the Enemy Act of this country, you're equated to discharge a further obligation. But if they refuse to abide by that, it is entered into this, a usufructuary contract of which the United States is the beneficiary. And you're the incidental beneficiary to ensure the contract be enforced, the third party.
So when the citation disappears, is that against the law?
What's that?
Is that against the law?
What do you mean?
If they take the original citation for their stock market, put a lien.
All right, that's their right to that fruit. But they have to pay all the taxes again, which means they can't come to you to pay for it. They're supposed to be the ones paying the face value on that damn, that's the insurance policy for it. That's like the premium. It's the insurance premium on it. So the $160 ticket, that's the insurance premium for it. And whatever they make on the market, they make because of the use of fraud. But they're the ones supposed to be paying that shit. I don't care what they do with all this stuff. They can make as much crap money as they want. It's not mine and it's not for me. It's for them because they believe they need it. All I'm doing is giving them the love to do so. And if they want debt, they can delve the debt up the sky themselves. It doesn't matter to me.
So they violated every single law
Mhm.
that I presented, and they created a judgment of $727.
Okay.
Now, the judge says you pay money order checks what the federal court accepts.
What the
She said.
federal court accepts.
Yeah, she said.
Federal court should accept your acceptance and deposit under 28 U.S.C. 2041. Deposit of any monies or other valuables in with the court. They have to put it in the treasury. They cannot hold it themselves.
Right.
Aw.
What was that again?
28 U.S.C. 2041. Deposit of monies or other things to the courts. They must deposit your acceptances with the treasury. They're not allowed to hold them. If they hold them, what are they doing?
unlawful conversion, embezzlement.
Exactly. They're withholding benefits from the United States that the United States has already purchased.
Piracy.
It's called dishonor. It's called piracy, belligerency. You can put whatever words you want to put in there. But the thing is, it undermines the national security of the nation when they do that. So they're purposely undermining the security of the nation to allow the United States to default, go into bankruptcies, and do whatever else it's going to do in the international arena to facilitate the destruction of the grand experiment. That's what they're doing. And our job is not let that happen.
If I may interject something really quick, their ancillary business operation under the SIC code and their court registry investment services, every court case in this country on the 1st and the 15th is channeled in Chicago, the Chicago Board of Trade, where they package them together and then do their ceremonial bloodletting at the Chicago markets. That's where the major meat market packing is. After it goes from there,
That's what I call the Chicago Bulls.
the Chicago Bulls, yeah. They let the blood. And then it goes from there, it's packaged together, and goes on to either a real estate investment trust or mortgage-backed securities or collateralized debt obligations on to New York, on Wall Street, where they package together
Okay.
and sell them
Now-
like mortgage-backed securities.
Now, when you're in your mortgages, okay, if they take that note, you get something in there that's, where they deposited it, what has just occurred?
Fraud.
Violation of pooling service
Okay.
agreement,
Came as
violation of New
security.
York State trust law.
They've done a couple things. First, it's called securities fraud. Why is it called securities fraud? The mortgage they sold on the market no longer has an asset backing it. It's gone. You're supposed to sell that mortgage plus note equals the security they can change, but you get rid of any one of these parts, this doesn't exist. But they're out there selling this in the stock market. It's called stock fraud, it's called investor fraud. This you report to SEC. Now, if they take that note and deposit it, okay? Now, there's a whole other issue because they never had the right to do this. You never gave them the right. That note was supposed to remain here, so when you pay off this mortgage, the note comes back to you so you can do this and nobody ever collect on it again. The second note, they denied this event from happening. They denied the future from happening of the return of the note. Now they owe you a new future or a new security. Why? Securities are just futures. And since they decided they were going to exercise a right, remember that, the exercise of right, the simple exercise of the right creates a use of fraud.
Why not
Well,
take
what
the
you're gonna
promissory note and accept it for honor and send it to the treasury and be
That's what
done
you
and have
do.
no mortgage at all?
Right, but you do that too, but now if they don't do it, it's now a use of fraud in the ass end. So you're taking, not only you're taking it and defending the state by protecting the stock market, but now you're taking all of this, and this is what U.S. is beneficiary. Okay, this is what you're gonna be giving to the treasury. This event.
3949 days.
This is the one you give them. And let them go after them, and you authorize collection. You authorize the collection. This end of it, you report the SEC. They have forms up for that. Because they deposited the note, that means the mortgage and the note no longer equal the security. They have already sold it, you want the SEC to investigate. And they will go investigate.
Also, Schneiderman, the Attorney General for New York State, also has a hotline for trust violations, because the mortgage and the note had to go into the trust pursuant to New York State trust law, and to qualify with a pool and service agreement with a close of escrow in 90 days. Failure to do so now makes it 100% tax liable.
Right, they no longer have that tax.
Is that just in New York, or does that apply to
Oh,
all
no, all
Everywhere.
everywhere. Alaska, yeah.
So when they do this, and then they lose that 95% tax exemption too. Now it's 100% on the capital gain.
Yep.
And the capital gain is not just the face value of the note.
It's
The
the
capital gain is the note value face value
It's the whole trust.
plus any profits, which could be, I don't know, what was it, 170 times?
175. The tranches are about 70 times. The factoring by the banks is anywhere from 18 to 50 times. The insurance proceeds, the mortgage-backed securities,
So
the
if you
collateralized debt obligations. Yep.
If you have a $100,000 note, and 170 times that amount, now they owe a capital gain on that 17 million. The one who bring the claim had better be bonded. 26 USC 2032 capital A E11 is a qualified heir. They had better be bonded, or they have personal liability for 100% of that capital gain that they're trying to get.
Of the total amount of all the tranches and everything else.
Correct.
So you bankrupt them. Excuse me, Counsel, did you bring your checkbook?
That's a, what's that?
26 U.S.
26 USC 2032 capital A, parentheses E, parentheses 11.
Lowercase e.
Yeah, lowercase e, capital A.
So what, so the note has an endorsement that reflects the deposit.
Correct.
What would you do if they presented you the original note in court?
Oh, you would accept it right on the front, turn that thing over, and pay the Oregon United States. Why? You're the damn grantor of the trust. The only reason it's in court is because there's a defect in the trust.
Now, where's the place they can only deposit it with
Right.
the treasury?
The defect in the trust is you never assigned it anywhere.
It was abandoned.
How did they get assignment?
It was
Did you
abandoned.
know they have to put in a motion to even get grant to bid? They don't own that damn note. They're just making claim to the product and the proceeds.
If it's in a federal
Salvage.
court already,
Uh-huh.
in the case.
Oh, it's in federal court, it's even better. Because under Attorney General's manual, we found this, all negotiable instruments are governed under federal law, not state law.
Okay.
All of them,
Which includes the note.
which includes the note, and includes any securities. Securities are governed under Title 15.
Even though it doesn't show up on the SEC,
Yep, it's an unregistered security.
that's what I feel.
Now, one of the other things is too, is that when we've done a request to close of escrow and through discovery of what's known as a money net daily transfer log, and the money net daily transfer log shows from the district, federal district, or the Federal Reserve District on the source of the funds.
I've got a copy of that.
Oh, that's awesome.
I've got it
That's where it's
done in LA, and if I may interject, if you want to get, because this information, two attorneys I've been told have been assassinated over having possessed this.
Oh, yeah.
What happened in this document, and I did some research, MoneyNet is based in London, naturally. And
like the library.
what happened is, a fellow was helping a legal Latino immigrant. And in this document, all you see is numbers and stuff. You can't, if you just look at it once, you can't figure it out. So this guy researched it. He's a very, very nice guy. And he researched it. It says San Francisco Federal Reserve. It's got an account with the exact amount of the mortgage. Down at the bottom, it's got the bank and it had a number on it, which he thought would be the social security number. And he spent a couple of days thinking about it and he says, wait a minute, this guy's not a citizen yet. Maybe it's his legal alien number. So he went and called the guy up and checked and it was the guy's naturalization number. Now, here's the deal. The money never went to the bank. The money went to the title company and went straight to Wall Street.
Yes,
And
absolutely.
I got the document.
Now, the point of the matter is that on the MoneyNet Daily Transfer Law, you show clearly that the applicant was the source bank.
Correct.
And it's not the bank. It's the
Correct.
applicant's SSN number who applied for
Correct.
access to the Treasury
And
offset
I
and Treasury
can
settlement program.
verify what you say. I got
Yeah.
the document that proves it.
Absolutely.
Right, and it should be that way because we're each banks.
Yeah, exactly. Now,
Every one of us is a bank. We're the only ones who have equity, we're the only ones who can contribute capital.
I have a pen. The pen is mightier than the sword. Right?
It's on Title 31 USC 5213. It's on A,
Yeah.
number 2K, whoever issues become a financial institution.
There you go. So you issued everything, you're the financial institution, who the hell do you think it returns to?
Does
Not
anyone?
them, they're out just claiming it. They think you violated a contract, you didn't violate the contract, they're the ones who violated it.
In that title in M, it says the department and agencies of the United States is also financial institutions.
Correct, and this name is an agency.
Agency relations.
This is an agency of the United States. So whenever you see this name in a court document, you see it's the U.S. So state of New Mexico sues one of you all. What are they doing? They're suing the United States. That's why they're in belligerency. The child corporation is suing the parent corporation for performance of a contract by its agency. But when the agency went to perform it, the child said, "No, I don't want that." And he stomps his feet. So what does the parent do? He has to come down and go, "Shut up."
They do that.
Like your parenting skills, Boris.
That's the Monty Python Bigfoot.
Boys, did she repeat the 31, whatever?
What is it?
What she
What was that?
mentioned,
30, what was that?
31 USC 3113.
Section 5213, 3213?
Now, what is that?
And one of the section, one of the, I believe that's A, 2.
Any,
K is anyone who issues.
Now, is it K like this?
Yeah, yeah.
Okay.
yeah, anyone.
And one of them is basically says, the United States Postal Service is also financial institution.
You know, Gloria, if you're going to talk, I'm having trouble. We're not picking you up very
Yes,
well
yeah.
on the...
31 USC 5213A2,
Okay.
and then a K.
Yeah, I
Another
think-
one down below the, I believe this is all a list, a whole
Yeah,
list
just
of
read the whole-
your utilities companies, pawnbrokers, insurance agencies, railroad companies, a whole list of things that you never thought were financial institutions are financial institutions. Used car dealers are financial institutions. New car dealers are not libraries.
Libraries are financial.
They're all
institutions.
financial institutions. So when you issue an instrument, you're issuing your own paper.
Well, when you look at a 1099A, it says when the issuance of $10 or more, when you look at the definition, $10 or more, you're considered as a financial institution.
Yep.
Yep.
In California, Yosef L. talks about how if we are involved in a real estate closing, we are a financial institution by the
Correct.
definition. We are a private banker.
Correct.
We just don't realize it.
Correct.
You signed it.
And that's why we have reports of other people who have taken all the documents at closing, turned them over, wrote pay to the order of the United States without recourse on the back. Not only did they never get a book for payment, they've never gotten a tax bill, and they got a check back for the Treasury for the full face value of the note.
Redeeming lawful money.
At that point, you would turn around and give it back to the United States Treasury so that debt can be retired. Because what do you need it for? If you can write your own paper, what the hell do you need a check for?
what if the person's deceased
What's that?
from the loan?
It's easy.
Yeah. My father,
Deceased.
we're still paying the loan.
All that would unfall under law of inheritance to you,
Okay.
to take care of that
So
estate.
could I,
Yeah, you could do that too.
That's what
On
I
behalf
want.
of him, because you're the executor of that estate.
Thank you, sir. All right.
The executor of the estate, when you're coming into these things, it's Rule 17.
Ratification.
Under a letter rogatory, which is just a private communication between you and the court. Rule 17 is the real party of interest, and the executor can join any lawsuit he wishes and not be joined in.
It's not a lawsuit, we're still paying,
I
so,
understand.
so
I understand.
I could endorse it and I send that to the treasurer?
Yes, you send it to the Jacob Lou, or, yeah, send it to the Treasury. Jacob Lou, the head dude,
Yes, sir.
Treasury Department.
Alien property custodian.
Can that be done at any time, what you're talking about, taking all the closing papers?
Oh, yeah.
And write, with,
Oh, yeah, because
take the order of the
All
United
right.
States without recourse.
Remember, who's the grantor of the trust? There you go. There's a defect in the trust. I have every right to correct the defect in the trust. Right? As a grantor, do I have the right to correct the defect in the trust?
Absolutely.
All right. Assignment of the reversionary interest is the correction of the defect. That's the only reason it's in court, because there's a defect in the trust, because now there's something to come and quabble and squabble over the proceeds and everything else in the escrow. So what you're doing is you're dumping the escrow back on the United States so they can serve their interest that you just acquired for them.
But let me make a correction, 53, 1, 2.
53.
5312.
All right.
Thank you.
31 USC
Thanks for
5312.
being thorough on that. That's what it's all about.
And under Rule 17, when you come in, you're coming in defense of United States interests. This is all about a unification within one. So you're unifying your interest with the state interest to create a marriage or a more perfect union. This name is, you quote, Christ, and he will bring you over the threshold when you two are married. You're the bridegroom that goes with them, your interests. These two hook up. Interest plus name is what? Birth to a new age.
Age of the new dawn, or dawn of the new age.
Dawn of a new age, birth of a new age, however you want to do it. But when you marry your interest with the state, now you become the state.
And it's the rebirth of the
We've never
republic.
done that. Nobody ever realized that you do that. And it's the same way on the spiritual level. When you merge yourself with what the gifts the Father have given you, now you're taking everything that He did to say, we're going to try and shove it all into this human form. And you're like, okay, let me have it, boss. Let me have it, Father. That's what you're doing here. Same thing. You're marrying your interest with the state. You're accepting His Christ, and now that papal bullshit of 1213 can stop. The war is over. This is how you stop the war. You have to go back in time.
If I may take a minute, because I was going to do this after we did all this, but I have a particular interest that I think really bears in this, and it's kind of like unusual, and I want...
You want to come up?
No, I just want a little of your insight, because a year ago I'm learning, and I know more now than I did then. What had happened was, my wife and I had a house and a condo in Los Angeles,
Okay.
and when all the real estate stuff started back in 2008, 2009, we wrote letters to the bank asking them to prove that they had an interest. Naturally, they didn't produce any
Okay.
proof. So the letters went on for a year and a half, and finally it started getting a little testy, and I sent them a demand letter under the Truth in Lending Act and Fair Debt Collection Practices Act. They never produced any proper documents. Sue them in federal court. Both the cases are in appellate court in San Francisco right now.
Okay.
I can't get the court to act on it, and here's why I think why. I found a little bit of code in the California Civil Code, 1229. And in it, it says that only the grantor of a trust can revoke the power of the trustee.
There you go. Y'all
So,
fire the damn trustees for bringing the claims
so
in.
now let me tell you what happened. Made up a document, filed it with LA County, right? And guess what happened? No more paying of the mortgage.
Right.
And the bank is paying the county tax bill.
Yes.
My wife wrote out a check to the county and they sent it back saying, you don't pay anymore, the bank does. I don't understand it now, I mean then, but now I think I do understand it.
All right, what do you?
And so now the question is,
I mean, no, I
well,
want to hear what you, I want to hear what you have to say.
I changed the names of the players between the trust, the executor, and the
changed your
I
beneficiary.
told you, you fixed the defect of the damn
And I did it
trust.
by accident, I didn't
Yes.
even know that I did
But you
it.
fixed
Now,
the
now the
defect.
question is, I got these two cases in federal court, and I don't know what to do with them now.
What you actually did is you converted the concept of a non-judicial foreclosure in California to an actual demand of a judicial foreclosure in order for them to have standing and succeed on that judicial foreclosure, which they can never do pursuant to 1229 of the California Administrative Code.
That's
So they're
right.
stuck.
Man, I gotta learn more about this, because I'm not an expert in it, as to what to do next.
Basically, that's all the great discoveries are made,
Mhm.
by
You
accident.
stumble upon it.
And I found, just by looking under law, you know, the code there, I found out one, and I said, what the hell is this?
Right.
This is taking away all their power. And I-
You
Write that
corrected
down
the
on the
defect.
board.
What is it?
1229, of the
What's
civil
that
code.
California,
And probably every state probably has the same thing. What?
no, judicial states do not.
No.
Under 2071 of the California Administrative Code, where they ran the notice of the trustee's deed upon sale for 3 consecutive weeks, and then the clerk or the county recorder issued, or the publisher issued a statement under 2071, an affidavit showing it was ran for 2 weeks. That is self-authenticating exculpatory evidence that the intent coming from the filing of the bogus assignment of deed of trust, because we know that the notes and the deed of trust has got to be placed in the pooling of service
90 days.
within 90 days of close of
And I
escrow.
got them for fraud on all the documents, which are felonies with the county and felonies with the federal government.
I don't know, here's something else.
Wait, let me
Go ahead.
finish.
I'm sorry.
Under the substitution of trustee, if it's tied to that assignment of deed of trust, that is another paper trail. Then if they executed on the trustee's deed upon sale and actually sold it at the steps of the courthouse, oh boy, oh boy, oh boy. You want to get yourself a lot of trees and a lot of rope, because there's going to be a lot of
Alright,
people.
and now you have all that evidence, you have evidence that they counterfeited the security, right?
Absolutely.
Okay. I'm gonna pull up a brief, I'm gonna pull up the Hadman brief and I'm gonna show you
And
something.
I did all this by accident, I can't believe it.
I think it's page 43 is on there. Page 43 or 45.
Elliot, that California code, they're in, there's somewhere in there that says that it's actually judicial, but nobody's asserting that they're going with non-judicial. But Keating in his.
I want to do $100 million.
Black is talking about.
Really? Yeah, it's a nice round number.
It might be in that 30, is that what you're talking about? But it's in California where it's one of the codes that actually says that it's judicial, that they're all judicial. And it throws out its non-judicial, so check into that.
CA is all judicial.
It's, yeah, and that's an account. You still tell, have it. Yeah, what's that? Yeah, yes.
All right. What, Keating?
Yeah, Keating said that.
I can't believe I did this by accident.
Okay,
In that.
this is how you invoke
Use that.
international law. Since you have evidence of counterfeit securities, the Supreme Court has already held in 1877 that Congress had the authority under the Define and Punish Clause to declare the counterfeiting within the United States of notes of a foreign bank or corporation was an offense against the law of nations.
Wow.
Is that supposed to
Wow.
be Arizona?
You mean I can get people thrown in jail?
That means you can have the international community come and do it for you, if that's what he's gonna do it.
Now, if you're in a court setting and you bring this up to the attention of the judge and he does nothing on it, it's an immediate violation of Title 18, Section 4, which is misprision of felony.
Yes.
And he needs to be removed from the bench.
Now that you have evidence of fraud or counterfeiting within the United States of the notes of a foreign bank, you are a foreign bank or a corporation, was an offense against the law of nations, reasoning that if the thing punishable is one which the United States are required by their international obligation to use due diligence, it is an offense against the law of nations. There is no hiding from this now. This is how you get them into the law of nations. You point out the violation under the law of nations, and now they have no duty but to perform. And if they don't do it, then they're not in harmony, they're not in compliance with the rules governing the international community.
One little minor thing which might apply here if there's California people here interested in this. When I filed it with the county, they wouldn't take it when I first filed it. They said even though it was notarized, it had to be notarized by an attorney. Fortunately, I got an attorney friend of mine that notarized it.
Why does that be notarized by an attorney?
It may, I don't know, I'm just asking if that, why they would say
The only way
that.
I can see that being done is because the United States Congress has chartered the Bar Association to be over here, and maybe it would be done under the authority of one of their judicial officers instead of the authority of a state official.
Right, well, I just brought that up because if anybody from California
I know.
wants to do what I did,
Yeah.
they may require an attorney to witness the signature.
Okay. But the reality is, once you have evidence of their counter, can you bring that down?
Boy, this is powerful shit.
Go back, sorry. Yeah, once you have evidence of this, it's an offense against the law of nations. Now you have every right to come in and demand performance under Constitution, Article 1, Section 8, Clause 10, or they are guilty of aiding and abetting and offering material support to terrorism in violation of their duties to the UN charters, which are also in this document. This document right here is called the Hammond Brief.
It's at
That's
IamSomeDude.com.
IamSomeDude.com on the legal page. This is the Hamden Brief. This is the one I talked to you about earlier. I have marked it up and highlighted. I couldn't highlight no more. It was just so, I'd be highlighting the whole damn thing. All right, when I got down to this point, when I got down to this part, this is where it all hit, and that's how you get them, is in going into international, going into the law of nations where they can't hide. Nowhere to run to, nowhere to hide.
Is that page 62 of 120?
This is page, whatever it is.
Page 3. It's not page
65. I don't know what page it is.
Yeah,
It's in there, just search for counterfeit, it's the only time counterfeiting shows up in the whole document.
Okay.
There was argument about promissory note is being non-negotiable instrument or negotiable instrument. But according to
all right.
the law, Title 26, promissory note is a negotiable instrument.
Okay,
It satisfies the debt. It
Yes.
satisfies the debt.
correct, on when you gave it to them.
Yeah.
And when they deposited, they got the debt, so when they come
And it's
back,
right here,
Yeah.
in Title 26, Section 108, small e, 10, capital A.
But there's also,
And Title 26, USC, Section 1275, small a, 1, big A.
there's also a timeline that's associated with that. I can issue a promissory note, promise to pay you within 5 months. As long as it doesn't go more than 180 days, it's not considered a security. That's what the futures
that's right.
rolls into it. So you have to remember that. There's a timeline that's associated with that.
Anything over 90 days or?
180 days
Is,
becomes
security.
security.
Then it's no longer governed under negotiable instruments governed under security law.
SEC 1934.
Right.
So the, not only promissory notes, they basically talk about debt instrument.
Right.
And the debt instrument is categorized as a bill, bond, promissory note, and certification.
Correct.
Any birth certificate
Yep, sir.
satisfy the debt.
Correct.
How would that relate to 15 U.S.C. 78, C10 on the promissory note not being a security, or the note not being a security, not a...
The note is a security. If it's got more than 180 days, if you're signing a 30-year note, it's a security.
Yeah. And it's not, now it's not an asset they can use on the back of the mortgage.
That's right.
They can't bundle up and get rid of it. They can't get rid of the security. Security has to remain with them. They're not allowed to do anything with that shit. They can monetize it, they can lien against it, but they're not allowed to get rid of it.
If you realize that the total amount of shenanigans that these banks did with this creative financing, or whatever you want to call it, 17 trillion. Right now, as we're sitting here, it's about 162 to 163 billion dollars. The banks have been fined with and slapped with and too big to fail and everything. So if you look at the standpoint of the cost of doing business from 17 trillion down to say 107, say 200 billion. It's less than 1%, it's less than 1 and
Yeah, it's just the
3/4%.
cost of doing business today. Right, so what we have
Overhead.
to do, in
Overhead.
order to stop the business people, the businesses, you have to make the cost of doing business so high, they'll leave you alone.
And that's where the total amount of profits as a result of
Correct.
the tranches, the collateral
Remember-
debt obligations, yep.
They counterfeited. Once you counterfeit, you ain't entitled to shit. If you have evidence of it, then they come in as a foreign bank, you come in, it's an offense of the law of nations. Once you find this in anything, once you find the violation of the law of nations, they must act upon it. If they don't, they're just barbarians. And the international community don't like barbarians. Ask the Germanic tribes. They've invaded Germany many times because the Germanic tribes have a long-standing history of inviting people in and killing them. They are barbaric by nature. And those are what you call, those are the ones that moved out of that area down into Ukraine and all the other shit they call themselves the Khazars or whatever.
Ashkenazi.
That's what we're the Zionists of today, or whatever the hell they want to call themselves today. I don't care what they call themselves. The very action defines who they are. I don't need to call them anything. They do all good on their own. Everything they do.
They'll be the Celtic people.
Counterfeit means copy.
Yes, fraudulent. So once they took his note and they decided they were going to use it, they counterfeited this they counterfeited it. Claim it was theirs. You were the issuer of it. Why are they claiming it as theirs?
So
You
that's
didn't
why
give
they
it to them. You
have
told them to hold it for this.
That's why they have to bring the original.
They don't have to bring anything. You
Now,
ask them for it just so you can rip it up, so it doesn't go at issue. If they don't bring it, I don't care.
But it-
because
it-
now they claim ownership, now they claim a right to it. They're a usufructuary, it's over.
But if the promissory note goes into a trust and then it's tranched, and I've got proof of that, the note is like, I mean, their ownership is all over the world, it's fragmented, so, I mean, I know that once the note, the US Supreme Court there, 1873, that court, when you separate the promissory note from the deed of trust, it's no longer valid.
Right.
I use that in the legal
Now,
document.
when they go and collect these notes, and since the ownership's all over the world, which owner's coming to claim?
Well, but it said in the PSA that once it's put in, it's for 100% of its value, and no one can have a claim thereafter.
Correct.
So you're telling me I can get the promissory note back, or do I not want to get it back, or I don't?
No, you get it all, you do a claim and recoupment and sign it all over the United States, and let them have the proceeds and go after the criminals.
it's almost like a quasi-qui-time action, because what you're essentially doing is becoming a whistleblower.
Right.
And you're giving them an option to go ahead and do what they need to do. If they don't do it within 6 months, then theoretically, you have a right to do a qui-tam action, and you're entitled to 35% of the proceeds plus costs.
Correct. And what you want to do is you want to give them 100%, which would be the face value of the note times 170 or even 100. I don't really care what the value is. All I know is, go get them. I got a big junkyard dog. They don't have one. And now we're going to learn to harness them. Now we're going to learn how to harness that junkyard dog.
Now, the other thing of it is too, is that there's evidence all over the whole planet. You got Greece, you got Portugal, you got all these countries that bought these collateralized debt obligations and mortgage-backed securities as an investment vehicle, and they all turned to crap, because all they were was crap in a box with nice wrapping paper on it with a big ribbon. And Iceland ejected everybody. Now, this morning, they just announced that Iceland is forgiving the equivalent of $28,000 in debt to every homeowner on the country. So far, they've had 63,000 people apply for it, and it started 2 days ago.
Yeah.
So not only did they throw out the bankers and throw them in jail,
Right.
but now they're writing off, or they're decreasing, or they're alleviating or waiving the so-called alleged debt.
Because the notes that Ireland and all these other people have bought are counterfeit.
Thanks.
Therefore, they're against the law of nations. Iceland has every right to do this to the bankers, and they could not stop them. They didn't even try to stop them. They already knew the ramifications of their actions. The bankers know what they're doing.
This is why the banker committed suicide, right?
The key man insurance policies JP Morgan and Goldman Sachs has exceeds $200 million.
Yeah, the bankers are being suicided.
Yeah, it's called Key-Man Insurance, it's a dead peasant's policy.
Yeah, and instead of the hanging, they're just gonna splow. That's all.
And collect money on the insurance.
They're learning that song by Tom Petty. I'm learning to fly, ain't got wings.
Free falling.
Does this apply to unsecured debt as well?
Everything. Everything. Because unsecured debt is the same way. You take your credit card and you assign the version of the United States. The credit is already yours. You've already used it. It's your credit. You're the damn bank.
Forrest, I just got a quick, are any attorneys working with you? I suspect not.
Shoot, no.
Hell no.
Not that you want to.
Ask Jim how many attorneys I used to have.
I've heard a conversation where it got revealed and the line went dead.
Really?
Absolutely
Really?
dead.
They wanted to vanish.
That person has
Dead.
never been around and never come back.
Yeah.
Well, I
This attorney.
got, Thomas was telling me that a guy down in Florida, I think either Tampa or Fort Myers or Sarasota, he was in a bankruptcy case and he tendered a note for a $10 million bond into the court as an barfly attorney. And the debt was satisfied and everything, and he told the clerk of the court to go ahead and deposit the proceeds in the ILOTA account, which is the International Lawyers Trust account. It's administered on the City of London. And so it's supposed to be finalized by September 7th or September 9th, something like that. So all the excess proceeds of the $10 million bond
We're going to lawyers.
are going to International Lawyers Trust.
We don't want that to happen.
No, it's for the benefit of the client.
Oh, okay.
He's having arrows and spears and threats from the state bar and all this other.
Oh, yeah.
I mean,
Oh,
big
yeah.
time. Because why?
Now they have to work at the benefit of their client because now they're bonded. And he's the one who bonded them. And as long as he lives that bond's existence, and now they can't do anything against, they can't do anything against the adverse interests of their clients, which means they can't play this bullshit game.
That's right. And corpus juris secundum volume 7, section 4 states as soon as you hire an attorney, you become a ward of the court. So let's see.
Correct.
We went from a maternity ward to being declared as a ward and guardian of the state. Then we go into a court thinking we're going to get relief and remedy, and we become a ward of the court.
Legally
So,
incompetent.
So you become, right.
Right.
So you become basically in livery. And the reversionary interest is the way you get out because that basically sues your livery to pay for your release from the military servitude. Because that's what a suit of livery is. It's a release from the military servitude to gain your original rank of nobility or nobility.
Yeah. Look up on page 586 of Black's Law 5th, talks about livery, when it talks about a man reaching the age of majority. He can go in and sue out in a probate action for all the trust all the trust property pursuant to Article 4 of the Cestui Que Vie Act of
Which is
1666.
every single court case.
Right.
And every single court case is governed under these principles and military law. If these guys get in your way, they're gonna fly.
Yeah.
What is the law that says about 170 times the application?
No, that's based upon Neil Garfield, who's an attorney from Arizona, who's now down in Florida.
like
He
this.
did an investigation that realized that the tranches were done at least 70 times, some of them as much as 150 times. The mortgage-backed securities, the collateralized debt obligations, and then the fact that when you did the deposit of a note, after you signed that note, the bank has a right under the 1963 congressional hearings on domestic finance and credit to factor that. In other words, if I deposit that note, it's a demand deposit account, it's cash. I can loan out 10 times the face value of that $10 million, which is $10 million.
And then on each loan, I can do 10 million. 10
Correct, so it becomes 100 million.
Correct. So when I,
So it's exponential, so you have the 10 times.
Unlimited
but
funding.
each 10 of those times has 10 times.
Unlimited.
Each 10 of those times has 10 times. Each so on and so forth. So suddenly you get something that's been fractionalized out.
170 was just a wild guesstimate. But Neil Garfield has testified this. If you go to livingwise.wordpress.com,
Yeah.
he's a phenomenal man. He's been doing this battling against foreclosure since 2006. And another phenomenal website is MSFraud, which is mortgageservicingfraud.org. They probably have on there in excess of 8,000 different cases. They have a legal lounge there. And I can show anybody who wants to see it on a computer that has access to the internet, I can show you how to go on there and look for stuff. It's a phenomenal resource.
First one was that?
The first one is livinglies.wordpress.com. That's Neil Garfield. And he was a trader on Wall Street securities for 17 years, so he knows the whole inside and outside gamut of it. The second one was MS, that stands for mortgageservicingfraud.org. And that's a phenomenal site.
What you have is when you're dealing with derivatives in a debt-based system, 0 is God, $1 is quote lawful, $5 is 1/5 of that dollar, $10 is 1/10 of that dollar, $20 is 1/20th of that dollar, 100 is 100, so a million would be 1 million. When you add up all this shit again, you should end up with this number, which is the amount of money allowed in circulation as per the 64 Banking Act.
Correct. 300 billion.
Now,
300 million.
here, a little factoid, guess what they did with gold? You can go up on YouTube
300 billion?
Yeah.
in a congressional hearing. They had the commissioner of the commodity markets trading thing. He admitted in front of a committee under oath that they're leveraged 99-1 in gold.
Yes.
No, that's not true. It's more like 250 to 1.
Well, that's what he admitted to.
Yeah, that's what he testified. But
The one-
you show me one man who's ever told the truth in front of a congressional hearing.
Howard Hughes! Howard Hughes!
I'll eat this substance.
Yeah, well, so when you're done, there may be $700 trillion in derivatives, but when you factor in all
Yep,
of this,
yep.
it's all gonna add up to the same amount of monies that are allowed in circulation for the 64 Banking Act.
Total amount.
Total amount.
Worldwide is
Global-wise.
2.4 quadrillion in derivatives and unfunded liabilities for all governments.
So when you go in and add it all back up, this is the number you'll add up to. Because remember, each one of those derivatives is 1 percentage point of $1.
Now,
So in the end, when it all comes crashing down and someone has $168 million in their bank account, what do they have?
$1.
Not even. They have 168 millionth of a dollar.
Yeah. The decimal points. Now, if I may say something really
And the
quick.
merchants will howl and the rich will be pissed, you know, that kind of stuff.
On the $1 bill, the Federal Reserve $1 note dollar, which is legal tender, that has, on the back side of it, it has the Great Seal of the United States of America. Every other, the 5, 10, 20, 50, and 100 are all issued out of the Federal Reserve System, where the Federal Reserve dollar, the $1, is the Federal Reserve Bank.
Yeah.
Okay? Now, on the Federal Reserve note, it's got the Great Seal of the United States of America, and on the Walking Liberty, it is also associated with that. So now, if I was to look at the so-called rate of deflation or inflation as it relates to acquiring 371.23 grains of silver, i.e. a dollar, it now takes approximately $20.90 in federal fiat to acquire $1 in substance.
Correct.
And it's being suppressed massively.
And really, the substance there still is worthless until it's used.
Correct.
So all it is just
Collecting
sitting
dust.
there, collecting dust.
And there's a video on YouTube. A guy said every morning, Monday morning, somebody's going on and lowering the price of gold and silver. And it showed it exactly at 8:30 on the
They call it
chart.
the plunge protection team.
Right, yeah, 8:30 in the morning on Monday, they're trying to drive the price of gold and silver down.
Correct.
4 o'clock in London is the one that's
See,
fixed.
Yeah.
when you attempt to control a system, you have to advertently entice its participants to supply the energy for that control. That's why they do on TV with your advertisements and everything else. They're advertising the life that they want to sell you, a vision they want to put on you, a chain they want to bind to you. Why? The amount of sheer energy to keep this the way it is so monumental, they can't do it themselves. They need our help. So the way you stop it, stop helping them.
They're utilizing hypnotic induction, which is a direct result of the Hegelian dialectic coming to this full form and creation. Problem, reaction, solution. So advertising is nothing more than hypnotic induction using all the principles,
Neuro-linguistic programming.
neuro-linguistic programming, all harnessed by Hegelian, which all the governments of modern time have used to dumb down the people.
Go ahead.
I'm sorry, you guys are just moving on so fast, and I wanted to interject this in there. You were talking about this applying to
of debt. Does that include the IRS?
Excuse me?
The IRS?
Absolutely.
Absolutely. The IRS has to take whatever debt instrument you give them because they're a protection of you. They're the ones holding the lien against all the people to protect them from the bankers. If they don't do it, they just threw you to the wolves. Now under international law, you have the right to come in and rearrange your affairs to account for that because you relied on them for protection, they abandoned you.
How do you enforce it?
Huh? Same way, law of nations. You would have to come in through Attorney General and other stuff. But the IRS agents themselves are all personally liable for their actions. If they don't know what they're doing, they shouldn't be interfering with accounts.
That's why they won't sign anything.
Yeah.
Yeah, we've actually had people send in monopoly money, and it worked.
Yeah. They don't care. They just want money.
I swear to you, it did.
It works.
It worked. They never heard from them again. IRS,
That's all
third-party debt,
Federal Reserve noted, it's just monopoly money.
Third-party
And
debt
guess what we
collectors.
just did?
because they don't
We learned
ask,
the rules of monopoly.
well, they don't ask what they want.
These are the rules of monopoly. Now we no longer play the
Yeah.
boardwalk
Hey,
rules.
you guys talked about that,
Now you can be the one that actually moves around the little thing there, you can play around in it and build the hotels and do whatever, instead of being the one that pays for it all.
huh? Right. Pay here, yeah.
Yeah.
All right, and these are the rules of monopoly. Yeah, get out of jail free, all the good stuff. Take a break. Take a short break here.
All right.
Green.
Whoa.